You are live.
Good morning. This is February 2nd, 2023. This is Senate Judiciary. February 2nd is also Groundhog Day. And for those of you who missed it, Tawny Phil predicts 6 more weeks of winter.
That'd be great.
With that weather forecast, our first witness is Judge Thomas Zone, Chief Superior Judge of the Vermont Judiciary. Good morning. And we're taking up S36 and accolade committing an arrest without a warrant for assaults and threats against healthcare workers and disorderly conduct at healthcare facilities.
So good morning. My name is Tom Zone, for the record, Chief Superior Judge. With respect to S36, the position of the court is that this is really a policy bill. Rule 3 of the Rules of Criminal Procedure currently has requirements for when an officer can arrest someone for a non-witness misdemeanor. That rule has 17 current exceptions that allows an arrest for a non-witness misdemeanor. And what this would seek to do is add 3 more there. That's a policy decision for the legislature in terms of the impact on the courts. We would be dealing with the case that is charged, whether they're arrested with or without, whether they're arrested as a non-witness misdemeanor or as a witness misdemeanor, and so that the impact on the courts would not be something that would be negative. We would address it in either event. I would note that at least one of these, for instance, the misdemeanor involving an assault, is already fundamentally in the exceptions because it allows an arrest without a warrant for a simple assault. And if you assault a healthcare worker, you have in effect performed a simple assault against a protected category. There's also a provision of the law that allows for an arrest if someone's continuing the crime, and that would seemingly capture the disorderly conduct. So really, it would appear that the only new one, if you will, is the criminal threatening. But again, that's a policy decision, and the addition of the other 2 would seemingly clarify matters for law enforcement on the ground. Any questions I'd be happy to address?
Yeah, just one question, Judge. The one thing that I brought up yesterday was the disorderly conduct part of this, and I support this bill in general, but my only concern is the individual in the hospital who's going through grief, trauma after losing a loved one, or someone getting a serious injury, and my only concern is where that line is drawn between expressing that grief and then it turning into disorderly conduct. And some of the hospitals voice it. Of course, they're trained in handling grief responses, but I'm just wondering if you have any thoughts on that delineation between the 2.
But it really is, that's a policy decision, but if you look at exception 3, let's say someone is in the hospital and they are experiencing grief and they just keep acting. Well, exception 3 says arrest is necessary to prevent the continuation of the criminal conduct for which the person was detained, to prevent harm to the person detained or harm to another person. And so if the person's continuing to engage in disorderly behaviors, that would seemingly already allow the officer to take action. And so it seems like it really is a matter of discretion on the ground for the officer as to how he or she wishes to go forward after speaking to the affected parties and perhaps the state's attorney.
Yeah. Thanks.
Other questions for Judge Zone? Thank you very much.
Thank you.
Next witness is Tim Lotus.
Thank you, Mr. Chair.
Tim,
I'm going to try to join.
why do I keep messing up your?
It is difficult. For generations, people have been messing it up. But just like the measurement leaders, or not like that.
Thank you.
I'll join without video. I'm going to share my screen just for a slight visual aid. My wife told me it's good to use visual aids, whether or not they're helpful or not, because it makes things more fun. All right.
For whom?
For you. Joining with computer audio. Got it. Share screen. For the record, Tim Leaders Dumont, and I'll mute myself.
You're echoing.
Tim Leaders Dumont, the Department of State's Attorneys and Sheriffs. And can you all see that up there? Okay. So first thing I'm doing is copying something that Judge Zone already did. He presented this very helpful arrest without a warrant flow chart to House institutions last month. And I immediately sent it out to law enforcement and our folks in the field because I found it to be helpful for folks that are still in the beginning stages, folks that are still going through the academy, for example. But concerning what you're contemplating here, S36, the state's attorneys, particularly the state's attorneys and deputies that are on call overnight, engage with law enforcement with Rule 3 all the time, as former members of law enforcement in here know well. And we have heard that members of law enforcement attempt to memorize Rule 3. Senator Sheena told us that yesterday. And so we do think that additions to Rule 3 that help specify your policy direction, like you've done with domestic assault, are helpful in terms of setting some of the guideway when someone is dealing with these, because as former members of law enforcement know in this room, these are typically fast-moving situations, and people with photographic memories are thinking, oh, there's 17 exceptions for when I can act right now and arresting someone without a warrant. And I really appreciated Attorney Fitzpatrick's testimony yesterday, because he clarified that it's not the misnomer of Rule 3 is that it is witness behavior, just not witnessed by law enforcement. So there's witnesses in hospitals, obviously. So it's a place where there may be many eyes on the situation. And so probable cause may be immediate with respect to some of these fast moving situations. As noted by the judge, there's already exceptions in Rule 17 that provide, and going to be a lot of words on the next page, but it's mostly just to be helpful to show just the breadth of the exceptions. And as noted, the continuation exception that the judge just discussed is always one that can be utilized depending on the circumstances. And the domestic assault one is something that everybody that's been on call has received those calls. And it's so nice to know that law enforcement, you don't have to fuss through the facts too much to figure out how to help that law enforcement officer when they're asking, what can I do right now? And they can arrest that person even though they weren't there when the domestic assault took place, which is, helpful to give clear guidance when you're, whether you're a new prosecutor or a new law enforcement officer. It's always very helpful. In thinking through the one of the sort of side effects of this is maybe a training, something we can do on the training side with law enforcement and deputy state's attorneys, but this is a non-exhaustive list in a way because of some of the, they aren't just exceptions, some of these are factors too. So whether or not someone has, the person is has proof of identity, that's a kind of a clear one. We don't know who this person is, we're gonna bring them in and kind of continue the investigation here and see what's happening. Whether or not there is a likelihood that the person, based on prior situations, they're gonna appear in court the next day. They call up the deputy state's attorney and the deputy state's attorney says they have 5 failures to appear. The officer can then use that as an exception under Rule 3 to say, we're gonna make sure this person appears. We're going to arrest this person. We might release them for a cite later on. We're gonna arrest them right now and sort of get the situation on the track so that we know they'll appear in court. So again, I'm not going to actually walk through all these 17 because I think the focus here is adding to the list. But when you add to anything, the tension is that some folks might think you're enumerating the entirety. And I think as a training point, we can all do a good job in terms of our prosecutors saying, this list provides some pretty clear exceptions and some that are more factors and circumstances. So I often hear it said that it's not just exceptions, it's factors and circumstances plus some clear exceptions. And the last point, just in terms of your policy prerogative on this, and the reason why it is helpful to put things in Rule 3C is because Rule 3F says that they shall be released on a citation if none of the exceptions apply, or if later on down the line, some of that stuff dissipates and then the reasons for it being there kind of fall away and they have to be released on a citation. So that could very well be one of the Rule 3C exceptions applies. They bring them to the police department or they bring them away from the hospital, and then the person calms down and they do receive a citation and they aren't held or they aren't even given any conditions and kind of thing. One point that I hope not to stress too loudly, but when I sent this out to our field, they did want me to note, as I often am the messenger here, this is a category, the misdemeanor categories that you're discussing, as you heard yesterday, do often result in a diversion referral. And that's because there is presumptive diversion for qualifying crimes, including crimes with elements of violence. Tamarack was designed to help people that are going through mental health issues, substance use issues. And so always a fact by fact, circumstance by circumstance kind of analysis goes into whether or not a prosecutor will object in the interest of justice. But certainly, if there's a clear exception in Rule 3C and there's lots of facts, a prosecutor could stand up when they're doing their information and say, we are not going to refer this person to diversion in the interest of justice because this was a very violent situation. That said, it's case by case.
I'm less concerned with the outcome of what happens. It's the removal from the emergency room or wherever of the person who is creating a disturbance. And that, I think that was behind this. And, you know, it's like any other crime. You deal with the perpetrator and the victim and try to separate them. So in domestic violence, you know, whatever the outcome is for the accused, it is what it is, but it's removing that person from the immediate area. And that's the most important. I wanted to ask about threatening, because I'm reading from Patricia Johnson's testimony yesterday morning. It was a little bit garbled, but she did send her actual testimony. And this threats on my life. S36 has the individual moved from the situation immediately. It would have prevented a patient from maybe being able to circle the parking lot, waiting for me to leave the building after making statements harming my life. We also spoke about hate speech and racial slurs after a patient was unhappy with her inability to receive a medication she felt she was entitled to, repeating and screaming the N-word over 30 times.
I think that testimony, it was all the testimony yesterday meant to start off by saying this was
Particularly to the threatening, because sometimes how would that be perceived if somebody is circling, threatening to their life or whatever?
So I know one of the pieces you all discussed last year with criminal threatening was the groups of people and sort of broadening it. And it would have to fall into the category that was not constitutionally protected, obviously, but that sort of clear physical circling that's happening, I think that could be certainly lead to probable cause if that were part of it. Oh, sorry, Senator.
So you feel like that behavior would be covered, but probably the hate speech would not.
I know this sounds terrible. I would have to know more about what was said and where it was said on the hate speech. And I know there's better experts on that than myself. But if I were making the call in the middle of the night, I always erred on the side of caution and would try to, like, if someone was circling a hospital and law enforcement called me and they said, we see this person, or we have witnesses who have seen this person circling the hospital, like the witness yesterday was talking to you about, I would say that person, if you're on the property of the hospital circling them and there's been threats like that, that's probable cause for threatening someone. It's a physical act combined with some verbalization or written words. I can't remember what happened with Ms. Johnson, but that was all kind of merged into a pretty, merged into a threat that was more than just, I'm going to come to your house at some point. You know, that sort of ambiguity would make me feel uncomfortable, but the clear physical acts with the verbal in time and place would certainly lead me to err on the side of.
Thank you. Senator.
So I have two things. To your point, Senator Sears, I think we may need to look at the criminal threatening work we did last year and include healthcare workers in that, because it sounds like they may not currently be. Someone said yesterday that they weren't. I think it might have been Senator Hart.
They are.
Okay. They're not. So I think we.
Unless they're a public, so the individuals that work at the state hospital.
Because they're state workers.
Yeah, I mean, there's certain.
But I think we may need to revisit that and
Yeah.
expand that to include healthcare workers.
And the VA as well in White River Junction.
Yes.
So that's one piece. My next question actually is around the Tamarack program, and it gets a little bit to what Senator Hashim was pointing to. And that does, for referral to that program, does one need to have a chronic mental health issue, or could it be an acute mental health issue due to, say, grief or an immediate trauma that occurred?
So as long as it were a misdemeanor, I think that the prosecutor would just look at the affidavit and, again, thinking that it's presumptive when we make the decision to not refer someone in the interest of justice, we're making an analysis about whether or not that person can be successful. So often I'll call diversion and I'll say, here's the circumstance that happened in the affidavit. Are you comfortable taking this? Before I'll even do the referral, I'll try to talk to them. And then they'll say, oh yeah, actually, we have a great thing that we can do with this person. And in fact, we're really glad you called us. Or they'll say, oh my gosh, that's totally out of our depth. And we're not comfortable with that, given the level of violence. Maybe that took place. So it totally depends. And I've certainly had ones where someone had an acute situation, they ramped down, they got re-engaged with family and whatnot, and they were successful eventually.
Okay,
So I hate to say that it depends all the time, but it kind of does.
understood. Everybody's different.
Yeah.
And then my last question is, I mean, maybe there is no answer to this, but for people who have not gone through the process of trying to attain a warrant, how long does that process usually take?
It could be very quick. It could be very quick. But that said, the situation where we're really engaging with warrants is if there's an investigation that's happening and it can't be located, that's where the state, our folks would get involved with the creation of an arrest warrant in terms of locating someone that knows they're kind of the subject of an investigation and then probable cause is there and the officer has tried all the different places to locate them and then they'll call us and they say, we have probable cause on this case and we want an arrest warrant and then we assist with that.
Okay,
But it does, and it could take not long at all.
okay.
But it is a step that can, in a situation like this, lead to, I mean, given some of the testimony you heard yesterday, I'm not going to rehash it, but the gentleman that you heard from at the end of the day, where it was calm and all of a sudden it was not calm, and obviously had life-altering situation. So that split second, whether it's a half an hour or 2 seconds, can mean everything.
No, absolutely. I certainly don't want
Oh,
to
yeah,
diminish
totally.
that. My only experience with getting a warrant is like Law and Order. So I wanted a more realistic sense of what that looks like.
Open invitation, and then wants to do a ride along with any of our Washington County folks. I'm happy to do that. I will even do it on a Saturday if someone wants to come with me.
Okay.
I was just gonna say, to your question about criminal threatening, I looked it up. It is, under 1028, section D, it does include healthcare workers or EMTs as protected professionals. It also includes a healthcare facility.
And that's what I thought.
Okay.
You had 1028 yesterday.
Yeah. Just so we know.
Gee,
Thank you, because
the old guy was right.
yeah, I bet you're right a lot, Senator Sears.
But other than that, just going to echo what Judge Zone said as to it being a policy choice.
I do have and I don't know, it doesn't need to be written into the bill, but I want to remind everyone that people in crisis sometimes act in odd ways. And it is removing them from the situation that's the most important piece to me. It is not necessarily what happens afterwards. And I did hear, from several witnesses about, that nothing really happened and blah, blah, blah. The point is getting that person out of the emergency room or wherever, whether they're and that's why I think this is an important bill. Not necessarily because I want to see more people go to jail or anything like that. We found, I think collectively, over the years found that removing people from really difficult situations oftentimes leads in pretty good results. And that I hope is clear to people out there who may be listening or others.
And one comment on that, if I may, there is the protection in Rule 3 already, as I discussed in Rule 3F, where that removal can take place, like you've already made clear, in the domestic situation in simple assault. And then once that situation dissipates, could be an hour later, 2 hours later, falls away, Rule 3F says that the exception no longer applies, and then they have to be released on a citation. So that protection is sort of built in there.
Thank you. Well, and I absolutely agree with you, Senator Sears, and to your point that people in crisis sometimes behave in odd ways. I want to think about how we do the removal just in terms of exacerbating trauma and exacerbating what someone is going through. And certainly we have unfortunately seen some instances where people in mental health crisis have ended up dead because the response did not really meet what was going on. So I just, with caution, want to think about how that's happening. Statement, not a question.
No, I totally, one of the things I was listening to yesterday was Senator Hardy brought up, folks in mental health situations, and that tug and pull that Attorney Green talked about too, about the duty. And I'll say this, I wasn't necessarily going to bring this up, but I lived with my aunt who ran 3 emergency departments in New England when I was going to law school. And she would come, was living with her in Maine, and she would come home physically, not just mentally, but physically exhausted from the work she was doing. And she worked at the Springfield Hospital here in Vermont. The stories that she talked about were right on point with what you heard yesterday.
Is there, trying to figure out if there's some federal law that doesn't allow law enforcement officers to be in emergency rooms or in hospitals. You know of any?
Not offhand, I know it was discussed briefly yesterday.
In appropriations, Rich Westman, gonna need to follow this up, that we actually, because of federal law, had to make some adjustments. One law enforcement could be, I think St. Johnsbury had a police officer in their emergency room.
I was just gonna chime in, I mean, just to clarify, you're referring to hospitals contracting, hiring out? Yeah.
Yeah.
That was in the article.
Do you know?
Yeah, so it was,
I need you to identify.
oh, sorry. Devin Green, Vermont Association of Hospitals and Health Systems. The federal law does play into this in terms of, and the issue that happened a couple years ago was that the state was contracting with the officers and not the hospital contracting with the officers. And so it was the idea of officers participating in care or intimidating patients that the federal law did not agree with. They want anyone who's participating in the care of a patient to be trained by the hospital and contracting with the hospital under the hospital's
So they have
direction.
to, they can be certified law enforcement officers, they just have to contract with the hospital, not the state.
Correct.
Thank you.
And be trained by the hospital.
Can I just ask a clarifying question? And I don't know who's the right person to answer it, but is there anything in federal or state law that would prevent, say, if 6 officers brought someone in, officers staying to just keep an eye to make sure things are okay?
Yeah, so again, it might depend on what's happening. So if it were to be one of the, if there's an ongoing threat of a crime that's occurring, right? If it was, like what they were talking about yesterday from the experience that I've at least seen is someone's having a crisis out in the community and potentially it was physical in nature, which then potentially necessitated multiple officers bringing someone. And the sort of common sense gap of why did they then leave? It might be that the person may have at that point been calm. Maybe there wasn't actually any criminal conduct that took place prior to them coming to the hospital. And the criminal conduct doesn't take, even though there was a crisis that took place, it could be, we had a gentleman over the bridge in Waterbury that was following a group of folks who were going to camp, children. And there was no crime that took place yet, but there was a lot of noise happening. Could have been a disorderly conduct, but they took him to the hospital and prevented actually a crime from happening, and then he's okay. That didn't turn violent, but if it did, then the crime's happening there, and the witnesses to the crime are the people in the room that.
Well, but it did sound like, 5 officers brought the person to the emergency room and they all left. And the emergency room, I think in that testimony, had 6 people and 5 of them were females.
And I'll leave that a little bit
Less
to
than
the
100 pounds.
law enforcement folks, because I know there might be a training angle on that as well as a practice.
We're gonna look next week for somebody. But we don't need to answer that question about federal law.
I guess my confusion, police officers are at events all the time where no one's committing a crime, protests, gatherings, they walking up and down Church Street. And so what is to prevent a police officer who's brought someone violent in from stepping into the hallway and hanging out? They're not in custody, they're not providing care. Like, it happens all throughout our community that police officers are present because there is a risk of danger because of who knows what. So I guess I'm confused why in this particular instance, an officer couldn't be present.
Yeah.
I'm not suggesting someone be shackled to the
Oh,
bed.
yeah. I think one of the ways that this may come up is thinking about Berlin. They have Walmart's parking lot, which sometimes can be a place where things occur in the evening as well as the hospital in really close proximity. And so sometimes there's, whether it's a staffing thing, sometimes it could be 1 or 2 people overnight. And if a situation is evolving, even in a community with a fair amount of law enforcement folks like Washington County, there may only be a few people available. And so them staying at the hospital may mean that they're not responding to other calls, or that there's not a law enforcement need for them there anymore that they saw. Again, I can't speak for the situations that occurred because they all seemed, the ones yesterday were, I mean, they speak for themselves because they were so incredibly.
Are there any other questions for Tim? Jim, did you have anything?
No, thank you very much.
Thank you.
Since you want me to review those 2 statutes.
Yeah, please.
So it's one of those situations where it's great that everybody was right. So, so because you were referring to 2 different statutes, so because there are 2 different ones that are referred to, or in the page 76 as possibilities to add to the Rule 3 arrest without a warrant provision. So the one that you worked on last year, Senator Sears, just and over the last 2 years, assault of a protected professional. That was the one you were referring to as well as 13 to 1020. That one does have within the definition of protected professional healthcare worker. But the other one, criminal threatening, mentions some other specific aggravated circumstances for particular situations, like a threat in a secondary institution, threat at a polling place, threat at a public or private school. And that one does not, or in particular persons like candidates for public office, public servant, election official, public employee, etc. That one does not list the healthcare professionals. So I think that was the one that was being referred to.
Yes.
That could be added to.
Yes, that's the one I was referring to, wanting to make sure we have healthcare facilities and healthcare workers.
So, we're fair an amendment to add healthcare workers to 38.
1702, that one. You mean the statute number?
Yeah.
Yep. And the criminal threatening one.
Yeah. Our next witness is Matt Valeria. Then we have Jack Manila has appeared. We had him crossed off.
I imagine.
Morning,
Morning.
I'm Larry, Defender General. This is one of those interesting bills that comes up as a result of particular incidents that happen somewhat regularly, of course. I was mindful of the testimony from yesterday. I was watching, getting reports and the like. There's nothing about it that's unknown to me. These are the kinds of things when you deal with people in crisis that I'm not saying you should be expecting to be threatened or assaulted, but it's part of the job that you have to understand is going to be part of the job. We're obviously not in favor of that kind of behavior or condoning it in any way. I go back now to 2002 when the first bill that Senate Judiciary dealt with it for pretty much the entirety of that year was a rewrite of Rule 3. And over the years, a couple of things have been added, but not much. You don't mess with the arrest rule very much. You want to keep it as understandable and focused as it needs to be without creating a list of 30 things that you have to be mindful of if you're law enforcement on the street. One of the things that I am always worried about, and I bring this up every year because there are always some interest group, whether it's state employees, public officials, law enforcement, healthcare workers, EMTs, fire and rescue people, whoever it is who shows up who have been aggrieved by somebody's political activity, that they want a special law just for them to cover their the assaults that take place and threats that take place just to them. When one of the things that is really supposed to happen with criminal law is that it's supposed to be simple enough so that anybody can understand that the activity is criminal. By adding in S36, and I understand what you want to get people out of the situation so the activity doesn't continue. There's nothing about the activity that I heard yesterday that isn't already covered by Rule 3. Simple assault is a relatively broad little statute. It's actually a simple little law. And it's one of those laws that said, where someone is guilty of a simple assault, if they attempt by physical menace to put another in fear of imminent serious bodily injury. Okay? It includes criminal threatening as part of what a simple assault is. And you're also guilty of a simple assault if you attempt to do that, or if you recklessly do that. So it doesn't have to be intentional, it doesn't have to be purposeful or knowing, although those are clearly simple assaults when you actually do the act. It doesn't even have to be negligent. If you have a weapon or something can be perceived as a weapon, but attempts to put someone in fear of serious bodily injury are covered. I also looked at criminal threatening, and I brought this up when you decided to create a criminal threatening statute. Criminal threatening is already covered by simple assault. All right. If you look at 13 PSA 1702, a person shall not by words or conduct knowingly threaten another person or a group or particular persons, and as a result of the threat, place the other person in reasonable apprehension of death, serious bodily injury. This adds sexual assault, which I would say is serious bodily injury in a person or particular person. Bottom line is, this is also, as I said, when you're dealing with criminal threatening, already covered by simple assault, but you wanted to do it again, so you did. And you mentioned specifically DCF and all of the people who I already talked about, the DCF workers, election officials, so on and so forth. All of those people were already covered by the simple assault statute. They're already covered by the disorderly conduct statute. And disorderly conduct even overlaps with simple assault, because you can be guilty of disorderly conduct if you engage in fighting or violent or tumultuous or threatening behavior. That's not familiar. Again, going back to simple assault by physical menace, it adds things like unreasonable noise, which depending upon what is going on, what you are saying, or what you are shouting or the noise you are making, can either be protected speech or protected activity, or it could be a crime depending upon what you're doing. In a public place, uses abusive or obscene language, again, depending upon the content, it borders on constitutional, a constitutional issue. And if you look at Rule 3, I thought I had this highlighted so I could see it. I must have had it in my all of these things are already covered by Rule 3. It lists simple assault. It lists if an officer comes upon a scene and there is witnessed tumultuous behavior that causes physical menace, threatening and the like, these are already covered under the rule. And I think that Tim Lueders-Dumont did a good job of showing that. I think what I did is I put my own highlights on the computer and not on my printout. Nevertheless, so you get an interesting situation here. I think every single thing that you're trying to accomplish is already covered under Rule 3, already covered under simple assault, already covered under criminal threatening, already covered under the breach of the peace statutes under Title 13, and allows law enforcement to arrest for the activity when they come upon it.
If they witness.
It doesn't have to be only witnessed by law enforcement.
Or they have to have.
Probable cause.
probable cause.
Right.
Yeah.
So even in instances where they talked about somebody was threatening me, swearing at me, calling me, racial slurs and the like, and was driving around the parking lot, that's covered under stalking under Rule 3. And the bottom line is, what I see here is, what is law enforcement doing? Is law enforcement not arresting these people for some reason? To me, this is, you don't need to create a new law. You need to get law enforcement to enforce the law that's on the books. To follow Rule 3, understand what the elements of simple assault are, understand what Rule 3 is all about, and how they work together. So the conundrum is, do you add something, do you change the law, but you don't really do anything because you're not adding anything to it? Or do you leave it alone and train better and enforce better, and officers use the discretion that they already have under Rule 3 to make arrests and diffuse situations or separate people from situations? Because ultimately you're going to come to the same result. I don't know why, if somebody is saying, I don't have authority to arrest somebody and separate people from the situation based upon the testimony that you heard yesterday, well, I don't know what's going on. I don't understand.
Can I just make a comment real quick?
Yeah.
What your testimony has me thinking of, it has me thinking of, why are some of these people being arrested? And based on some of the testimony I was hearing yesterday, that was the question that was going through my mind, based solely on what I was hearing from the witnesses. And, part of me is thinking that perhaps there's a liability concern among police officers who are going to a hospital or receiving a call and finding out that, there's somebody in a hospital who was there for a medical reason. They don't want to remove that person because they're getting medical care. And perhaps that's one of the concerns that's floating through their head, is them saying, this person came to the hospital for medical reasons. I don't want to be the person taking them out of the hospital and having them suffer an injury, a medical injury that's furthered because I removed them from the hospital. So they're staying here.
How does this change that?
I'm not suggesting that it does. I'm just sharing a comment that perhaps that's something that is going through their mind.
Yeah, I don't know that adding these pieces to Rule 3 would change that thinking. So, if you change it, I don't know that you're going to change behavior at all.
I think
If they aren't doing it now, why would they do it then?
because you've highlighted it, because the legislature has made it a priority, just the way the legislature made domestic violence a priority, by changing some of the laws regarding arrest without warrant. We continue to deal with domestic violence as long as I've been here. which is 30 plus years. I think our first bill that we worked on had to do with domestic violence 30 years ago. And I think we've continued to try to highlight that problem. The problem hasn't gone away. But I would say we're further ahead in terms of dealing with domestic violence than we were before. And I think the legislature, by highlighting and this problem in our hospital emergency rooms particularly, but it's throughout the healthcare industry, by the way. For some reason, people now feel, I don't know if it has to do with the former president or what, but people feel more free in questioning healthcare professionals and getting angry when they have to wait 15 minutes and getting angry when, they don't get the result they wanted, and then making threats. I think that's throughout that industry. And I'm happy with what we're trying to do. I think it's important. Whether or not they can already do it, you probably are correct, but they aren't doing it.
Well, they should do it. And I don't think that changing the law is going to deter the conduct any. I mean, you bring up domestic violence. That's the #1 misdemeanor, violent, quote unquote.
Well, where would it be if we didn't make the work that we've done?
I don't know. I just know what it is.
I understand that, Matt, but if you think back to the bills that we've worked on in the last, you've been here 27 years, 30.
Yeah, these are areas that I think have, just like this, have roots in something different than what you're going to try to accomplish with the law. So, I'm not all worked up about, are you going to put it in, or you're not going to put it in, because I don't think it's going to honestly do much either way. But people should be clear that current law provides for exactly what you're trying to do already. And it's even layered within various forms of criminal threatening that over the years used to be covered by a simple assault statute that have now we've got, refinements or you're including particulars in criminal threatening statutes because people didn't use the laws that were available to them. So, I don't think it's necessary. I don't think it does any harm, but I don't think you're going to get at what you're trying to get at. I really would suggest that there be some focus in this bill on training law enforcement and others who are dealing with these incidents, maybe people in the emergency rooms and the like, that this is available to them. An arrest to bring somebody away from a situation. You're dealing with a law enforcement implementation issue by changing the law when the law already allows them to do what they need to do. And I like to keep things simple. So that way the public understands simple. The more it gets complex, the more they don't understand.
I think emotions take over sometimes in emergency rooms.
I agree.
I think brought up a number of things, but anyway. So there are other questions. First,
I think I was just going.
So,
I don't want to be contradictory and suggest making things even more complex, but that's what I'm about to do. Could we consider putting in a provision where we state that if a police officer is going to remove somebody from a hospital, they have to be medically cleared first? I think that's something that could, if that police officer is worried about liability and, they're nervous about taking somebody out of the hospital, but you have medical staff saying this person's been cleared, they've also punched a couple people in the face, please arrest this person. That could possibly be something.
The problem with that would be I'm sure we'll hear from Jack McCullough on it, but I'm concerned about the patient who is not there for a medical, but a psychiatric issue, and may be cleared, but there's no bed anywhere for them. And that's part of the problem that our hospitals are facing, is they are stuck with this person. I dealt with 2 incidences. When I say I dealt with them, I only looked at the conduct between the state agency and the services and the hospital, trying to get rid of somebody who'd been there almost 30 days. And, you know, my hospital doesn't have, it's actually inappropriate because the people were in what you might call segregation during that period. I mean, it wasn't really segregation because they weren't in prison, but, you know, they just couldn't get rid of the person because there was no place to put them. And so they wouldn't have been medically cleared, but.
This is obviously an issue we're seeing more and more of our clients, because there isn't a, don't have a facility to put those folks that is safe for them and safe for the people who are at least safer for the people who are trying to treat them.
One was a DMH and one was a DCF kid who would have been appropriate for Woodside before the ruling by Judge Crawford. Would have been at Woodside, but it couldn't have been even at Woodside. They had no place for that kid.
And one last thing, we heard yesterday from a healthcare provider that, this is a baby step. And, and I hear where you're coming from regarding this not really changing much. But, there's also the fact that there are a lot of healthcare workers who feel like the state's not doing anything to keep them safe. And, I'm just thinking about the message that we're sending to healthcare workers and potential healthcare workers who want to enter the industry, but feel as if there's nothing in statute, even though there is, to keep them safe. So that's another thing that I'm thinking about as well.
I just suggest that, again, use the tools that are available, train the people to use the tools that are available. And once they start getting used, then maybe the healthcare workers will feel better about it. But, I don't think we're getting the underlying issue when it comes to the population that's causing the problem. And it's not a legal problem at all. It's as we often see, mental health issue, drug abuse issue, poverty issue, issues of despair and the like that aren't going to be dealt with by Rule 3.
The Defender General actually took the comment that I was going to make kind of right out of my mouth. I mean, so much of the testimony we heard were about people in despair, people with nowhere else to go, which is often who lands in our emergency departments. To me, I mean, this is a symptom of a need to invest in our communities. And I support any way we can keep our healthcare workers safe, of course, and I don't think we're getting even close to the real root of this problem.
And if I might, I think part of the problem is, and I'm not saying it's all the problem, but under Rule 3, a lot of these situations can be handled, and I think it goes back to the core of protection of our hospital workers and whatever else, and they're looking to remove that individuals from the hospital for their safety. But as we're all talking and hearing, okay, so now what's law enforcement do with that individual when Senator Sear says there's no place to put them? We can only hold them for so long, obviously, as you're fully aware. So what do we do with them now? So it's a community problem here. It's a state of Vermont problem, and I think that we should be addressing these concerns. But as the Defender General stated, we already have the ability to do just that. And I know the senator's concerns as far as helping out the hospital workers, and I agree with that because we heard some very emotional and traumatic stories yesterday. What law enforcement they have to be in custody for a minor violation.
The other thing that has come up for me from the testimony yesterday and from issues that I've dealt with in my own profession, and this is this is gonna be a GovOps issue, but I wonder if there might be some conversation back and forth, beyond what I will take to GovOps, is the mandate in certain instances that people's home addresses be listed alongside licenses, or particularly with remote mental health workers who don't have a physical office space in the state. They have to list their home address publicly. And I think that we need to look at the safety of that, given what we heard yesterday. And certainly, I mean, we've had some pretty scary situations. So I would love to dive into a bit of that conversation. Like I said, I know it's largely a GovOps issue, but I think there's some information here that needs to go there.
Any more from Matt?
Thank
Matt,
you.
thanks for being here. Stay warm. Jack McCullough.
Okay, thank you. Good morning. Thank you for the invitation. I'm Jack McCullough. I'm a lawyer, legal aid, and I'm the director of our mental health law project. And Vermont Legal Aid has a contract with the state, and we represent everybody in Vermont who is facing any kind of involuntary mental health proceedings anywhere in the state, including in the designated psychiatric hospitals and any other hospital in which someone might be involuntarily held for some period of time. So there's the mention of the people being in emergency departments, or the hospital down in Bennington, or any other hospital in the state. People wind up there sometimes because there's no psychiatric beds open for those people. The clients that we represent who are in hospitals they're involuntarily, and I think 100%, and they are there as a result of some kind of psychiatric crisis. First off, I should say that as far as I can see, this bill doesn't make illegal anything that isn't already illegal. It's just a matter of police response to these actions. The clients that we represent are being held involuntarily in a hospital. And I'm just thinking about what would potentially happen if this were applied to one of our clients. They do something potentially dangerous. The police come and they're arrested. Presumably they'd be arrested, they would be arraigned, and because they came from a psychiatric hospital, they would most likely then be ordered to undergo a forensic evaluation for competency and sanity. And where that would likely happen is they would be ordered to send to an inpatient facility to undergo that forensic evaluation. So likely they would simply be returned either to the hospital they were just arrested at, or some other psychiatric hospital. And this all takes time. And I think that part of what I'm seeing is that this bill overestimates the ability of law enforcement to respond to something like this. Because I know when the state hospital in Waterbury was open, at one point they installed these panic buttons in some of the visiting rooms, so that when my staff were coming over, they could push the panic button and get someone there right away. And someone might say, well, I've got my cell phone with me, I can just call the police. Well, how long is that going to take to get there? It's not going to provide any significant protection, because whatever was going to happen has already happened and it's probably over by then. The hospitals, and in recognition of this, every hospital has the ability to respond to an emergency in which someone is placed in danger by a range of emergency involuntary procedures. From what they refer to as brief hands-on, where just kind of take the person, physically remove them or walk them away, all the way up to physical restraints, seclusion, chemical restraints, involuntary emergency medications. And that all happens at the hospital, at the unit, very, very quickly. And I know they respond to it very, very quickly, and I've been at hospitals when those things are going on, and I know that they have very, very quickly. So I'm not sure that this legislation really adds to the protection of healthcare workers from, at least from the experience that of my clients, adds to the protection that they already have. I know that many of my clients get these emergency and voluntary procedures all the time. It's a very frequent occurrence. A question I have is that what's the definition of a healthcare facility and how would it relate to my clients, people who are in the involuntary mental health system? Because in addition to the designated hospitals and any other hospital institutions are held, there are all kinds of residential facilities. There are group homes, from the lowest level of confinement where the person's in some kind of group home that's staffed, but it's open and people can go if they please, all the way up to the facility that's now at Middlesex and is about to move up to it's called River Valley, but it's a locked facility everywhere in between. It's not clear to me whether those are all going to be considered medical facilities or are they something else? And so I think that's something it's clear on.
Healthcare facility. I don't know.
It uses the same definition that's used in the assault of a protected professional statute. So, okay.
The 1028D,
Okay.
1028D.
Correct, yeah.
Okay, I will.
I'm talking like a lawyer.
Yes,
enough
you
time
got
in
it,
this room.
exactly.
That's what happens. I think that there are a couple of other concern that I have is that in general, I don't think it's a good idea to add law enforcement into a psychiatric crisis. And I think that what we're seeing as a progressive move, and we're certainly doing it here in Montpelier, where I'm on the city council, and we have been working on this in our police processes, is we want to get police out of psychiatric crises if they don't need to be there. And I think that adding law enforcement to a psychiatric crisis probably escalates the situation more often than de-escalating the situation.
I did point out that we're not necessarily talking about all psychiatric. Right? I think as was pointed out yesterday, doesn't even amount to 50% of these cases. That many of them are people who are intoxicated or on drugs like methamphetamine, or are just angry at having waited and just frustrated and or maybe family members. One doctor was talking about the client was a psychiatric patient who had agreed and was not a problem, but the father couldn't handle that his son had psychiatric problems and began threatening the emergency room doctor.
Yeah.
I just wanted to speak to the point of regarding psychiatric patients and how there's really a range of what its incidents can look like. And, part of what you're saying, I agree with. I mean, when I was a new trooper, for example, I ended up in this very young person's living room with his parents. There were two uniformed armed troopers while this kid was having, a mental health issue. And, the first thing I thought in my head is, why are there two cops here right now for a child? The kid needs a therapist. But then, I'm thinking back to what we heard yesterday of the nurse who was punched so hard in the head that, he lost hearing and has PTSD. And, the person who committed that act based on what we heard, he was in control of his faculties, but was going through a psychiatric issue. And, in my opinion, what happened was a crime, and, that would require a police response. But also, yes, that person should still get psychiatric care. I just wanted to put that on the table, that, there's a wide spectrum, as you know, I know you know that, but I'm just saying it for the committee that, there's a wide spectrum of mental health incidents. Some require police response and some don't.
I agree with that, and I was in trial yesterday. I didn't get to see the testimony, but I did see part of that witness's testimony on the news last night, and it sounds like a crime to me. It sounds like it's something that the person could have been prosecuted for. I don't know whether he was or not, but I think that's a separate question from what's raised by this bill.
Another comment.
Well, to Senator Hashim's point, I think, this points to the need for us to invest in a more robust mental health crisis response system. I know there are some states that have begun utilizing a cahoots model of crisis response that is not police-based, but is instead a group of highly trained mental health responders in some of these instances. And I think that's probably a healthcare conversation, but I think it is critically important that we're having a conversation about how we respond to these things that aren't two armed troopers who are actually likely in many instances to escalate a situation, not de-escalate it, simply by their presence, not because they are doing anything wrong, but because there is just an inherent fear a lot of times when that's what happens, that will escalate many situations. And we've seen that happen and play out pretty tragically in some instances.
Yeah, I agree with you. I think that what the last police chief we had in Montpelier did was started the implementing CIT, crisis intervention team training. And I think that
I will really point out that in the meantime, healthcare workers are being assaulted, are being dealt with, and we need to deal with this problem, and you may be absolutely correct, but it's not just the mental health. It is, the workplace violence is unacceptable, and whatever we can do to prevent that violence needs to be done. I think the Health and Welfare Committee is going to continue to take testimony on this bill, and is probably the more appropriate place for questions like that about what you do afterwards. But what's going on, and I remind everybody that it's not only the healthcare worker, but several pointed out yesterday, and we've all witnessed it when we've been to emergency rooms. When somebody is dealing with a crisis that's created by somebody who's out of control and attacking a healthcare worker, somebody else who needs treatment isn't getting it. Could be a heart attack victim, could be a car crash victim, could be anybody. If somebody else isn't getting the treatment that they need while this healthcare professional is getting attacked, and I think that's an important part of this, that if we're missing, we need to be able to provide a safe workplace. If this bill isn't the way to do it, then I have to find another way, but I think the goal here is safe workplaces for healthcare workers.
I think that's an important consideration. I definitely do. I did have one question, one answer that I think to a question that I heard, which was, what happens when the police transport someone to the hospital, and do they stay or do they leave, and why? And this can be very quick, but in the cases that I see where the police are often the ones transporting someone to the hospital in a mental health screening or psychiatric crisis, and when they testify in court, what they generally see is they say is that they've gotten the person to the hospital, they handed off the person from them to the hospital. they're just not needed anymore. It's not a law enforcement function, and so they don't need to be there. And plus, staffing is a real concern. You know, in Montpelier, staffing, we've been in staffing crisis for several years, and other law enforcement agencies are the same. I learned in the consideration of one tragic incident that happened in Montpelier that late at night, there are only, I think, 4 law enforcement officers on duty in all Washington County. 2 police officers in Montpelier Police Department, 2 in Barry City Police Department. Even the state police barracks isn't open 24 hours, as I've been told. So they're stretched very thin, and so I don't think they're going to stay there if there's not a need for them to be there. They have somewhere else they need to be.
Probably right.
So, and that's all I've got. I'd be happy to come in. Thank you.
I'm sure the Health and Welfare Committee will have you in, Jack.
Yeah, of course.
Okay, thank you very much. That concludes the testimony on S4 for today.
Or S36.
I mean, S36, and we'll be back to it next week. Try to get the bill out of here and let Senator Ryan do what she will. When she gets to be able to. So we're going to take up S4 just for the juvenile and criminal procedures. We have somebody representing, we have the director of the Vermont Landlord Association.
Yeah.
And as well as, sorry. You can help me with the last name, I'm sorry.
Sure, absolutely. It's Sakowski.
Morning. Morning, and thank you for taking time with us this morning.
Absolutely.
Your particular area of the bill has to do with the landlords. And as I want to let you know that we're certainly open to adjustments, whatever, and suggestions. So please feel free to go ahead. I'm Dick Sears, by the way, chair of the committee. And Senator Baruth.
Phil Baruth from Chittenden Central.
Good morning.
Bob Norris, Franklin County.
Morning.
Tanya Vihovsky, Chittenden Central.
Good morning.
Not a machine, Dummerston, Linda Dummerston, representing Linda County.
Good morning. Thank you everyone for having me on. My name is Angela Zakowski. I am the director of the Vermont Landlords Association. We're a statewide trade organization for landlords. I'm also a practicing attorney. And so I represent landlords around the state of Vermont, primarily in eviction matters, but in lots of other issues that landlords face. And so I appreciate the opportunity to come in and speak about this bill, particularly Section 2. And as the way it's currently drafted, it would be extending liability to a landlord for the actions of their tenant. And so we would oppose this section as drafted. It reads as not very good policy in my opinion. But I think, I think there's some other solutions based on what I understand the problem to be and what's driving this bill. Maybe for a little bit of background, it is an incredibly challenging and long process for a landlord to evict a tenant in the state of Vermont. Even for something as straightforward as a non-payment of rent issue, that process from start to finish can take months, up to 6 months, sometimes 7 or 8 months. When you start talking about having to evict a tenant for cause, which would be in a situation like this, tenants violating the lease, they're violating the law, they're causing lots of issues at the property, that becomes something called a breach of lease case. Those are incredibly difficult. The landlord has to prove the allegations in the notice, so they have to have enough facts to support whatever the behavior is that they're indicating is happening at the property. Many times that requires other residents in the property to be involved in the eviction case. And I think what we see, and what I have seen in the instances of where there's allegations about drug activity and drug use, other residents in the building are incredibly reluctant to get involved. They believe it is a safety issue for them. They're fearful. They don't want to have their face on a screen or have the residents who are causing the problems know that they've made complaints or that they're taking action or are involved in any way. And so in many of these situations, landlords would use the no cause notice because they don't have to involve other tenants. But as we've seen, there's a movement in the state to try to do away with that type of notice. So we're seeing sort of a tightening of the tools that are available to landlords, and now, you know, a push to make them criminally liable for this behavior in a process that is very challenging for them to deal with. I want to be clear to the committee that I don't represent, and I'm not here to support those recalcitrant landlords, the ones who aren't taking action, who aren't dealing with the situation, but this bill extends to all landlords. And so it would apply to the person who's trying to deal with a situation, who's trying to get this tenant out of the property, but is faced with this very long and burdensome process. And so many times it can look like the landlord's not doing anything, or is not taking action, or is not dealing with a situation, or the landlord may not have the evidence to support taking this tenant to court to have them removed. And so all of these things create very big challenges if we're talking about placing liability, and particularly criminal liability, onto a landlord. What Section 2 also doesn't do is it doesn't solve the problem, right? The problem, as I understand it, is that these tenants are in a building, they're engaged in illegal activity, and they're not being removed from the building. And so it's a safety issue for neighbors, it's a safety issue for other residents. It's creating sort of chaos in a neighborhood, and holding the landlord criminally liable doesn't actually fix that problem. Those tenants are still there. It doesn't create a mechanism for having those tenants removed. And so I think some of the proposals I would have for the committee would deal with the situation and maybe give some other parties tools to have those folks removed in this sort of situation where the landlord's not taking any action or doesn't feel like they can take action. You know, one suggestion or one example is to do some sort of receivership process. There's a very well drafted receivership procedure in Title 33. It is used for long-term healthcare facilities, but it sort of lays out step by step. If there are these issues, the state can step in, they can take over this structure, run the operations, deal with a situation, sort of make sure everything's stabilized as a matter of public policy. That's one potential option, is to create some sort of receivership process where the town or the state could ask to take over the building to deal with the issue, have the tenants removed. Maybe a little bit cumbersome, but you know, something that the committee might want to consider. Another option is to add some sort of language to our current town health officer system to link this back to some sort of health order, make it something that they could issue, you know, orders within a process that we already have available to sort of push the issue with the landlord if that's what the committee is interested in looking at, you know, having something happen to the landlord if they're not dealing with the situation. Another thought or another suggestion would be to do some language or create some language that would authorize the town to commence an eviction action to remove the particular tenants that are causing the issue. You know, there would have to be criteria set out for what types of behavior would allow the town to step in and do that. But I think that we could probably use some of the language already drafted and the process already used for the unlawful occupant action. So that was something that was passed a few years ago. It's a very truncated eviction process for unlawful subtenants. And that's in Title 12. So it's the court process. That could be a framework that could be looked at in terms of giving a third party the ability to start an action to have tenants removed and get them out of the building. There is also precedent for, if a town takes this kind of action, to have the costs of that action become a lien on the landlord's building. So, you know, the town could have a method to recoup the costs of having to take this kind of action or push something like this forward. It feels like maybe some of those options might better address what I understand the problem is, which is that there's tenants in a building engaged in illegal activity, causing problems, and the landlord is not presumably doing anything to have those tenants removed from the building.
I have a question that might actually be for Eric around the sort of knowing and recklessly language, because my understanding of that is not demanding that a landlord evict someone or successfully respond, but that they have tried to make a response. They've called the police, they've begun eviction proceedings. So is that a correct read on that language, that it is in fact not applicable to landlords who have tried to do something? It would only be applicable to landlords who knew what was going on and have done nothing?
That was the goal.
Right,
I don't know how to write it.
right. I would read it that way, because the conscious disregard of the risk would seem to be inapplicable. If the landlord has heard about the circumstances in the building and has said, oh, it sounds dangerous, I'm going to contact law enforcement, I'm going to do what I can, that would not seem to be a disregard of the risk. However, to be crystal clear about that, it might be helpful to add language that said, you know, something along the lines of landlord shall not be prosecuted under this section if they have taken steps to contact law enforcement or initiate an eviction proceeding or whatever, something like that, that would show that they've taken affirmative steps, and that way there would be a lack of clarity about whether or not that would keep them from being prosecuted.
And that seems perfectly reasonable to me to more clarify the language, but the way I read this, a landlord who has taken any steps, they may not have been successful, would not be liable by this policy.
Yeah,
That was the intent.
Yeah, and I was just gonna say, you know, with what Senator Holsky is saying, that's what was going through my mind as well, is, you know, it's not this does not encompass every landlord. It encompasses landlords who are acting knowingly or recklessly to permit a dwelling to be used for these purposes. And, you know, when police are investigating this, ideally they're going to, you know, find out what steps, if any, did the landlord take. Did they call the police? Did they at least try to get an eviction started and then, you know, find out that it's going to be a lengthy process? I feel like those are pretty obvious steps that indicate that they're not deliberately disregarding the risks.
The case that brought this into the bill was an absentee landlord in Bennington, where the tenants did complain. They did do everything they could to get rid of, and I'm gonna say there were 6 other apartments in the building, but I'm not sure if that's the proper number. So the town began civil action with what may turn out to be not something that they are successful with. But the idea here was, in that type of case, where the absentee landlord, and there's no manager that we're aware of, has done nothing to respond to the complaint from the other tenants, who can't leave because there's no place else for them to go. You know, it's a housing shortage. So they're kind of stuck there. The behavior continued. So the town tried that civil route. But definitely the intent here is not to create problems for landlords who are trying to do the right thing.
And
we recognize that. So it was never our intent to have a landlord Mainly that was the situation, and I asked to be drafted that way to respond to that.
Right. And I appreciate that, and I appreciate the committee trying to be mindful of that situation. I think what I've run into and what my clients have run into and what landlords face is attempts to call the police in these situations are routinely and regularly rebuffed. The message has been sent to the landlord community that the police don't want to hear about it. Many times they won't take the complaints if the landlord calls. Sometimes they will. It really maybe depends on who's answering the phone when they call, but they don't get a lot of support or feedback in these situations. Sometimes they may hear there's an ongoing investigation. There's nothing more that we can provide for you. Thank you for calling. And I would again stress that in order for a landlord to take action in a situation like this, the landlord has to have evidence that would support their eviction. So they have to have credible evidence that they think they could take to court and win, particularly if they're using a breach of lease type notice. Now, it's less of an issue of having to prove that there's drug activity happening or that these tenants warrant losing their housing if the landlord's using something like a no-cause notice. If they're in a point in their lease where that's available to them. But as I mentioned, there are numerous attempts around the state to have that type of notice removed from the landlord's toolbox, so to speak. That is a notice that is frequently used in these settings because then it doesn't require other tenants to participate. Landlords can take the complaints from the other residents in the building. They can send a no-cause notice. They don't have to involve the other residents in the process. And if that notice is removed, then it is going to become even harder for landlords to deal with these types of situations and to be able for landlords to get rid of tenants who are engaged in this kind of behavior. Now, I can't speak as to why the particular landlord in Bennington was non-responsive in this situation.
I don't think they cared. I think they were just collecting the rent to live in Florida.
I have a question now for my two former police officers in the room about calls to the police. Are they all logged regardless of whether or not action is taken?
For the state police, yeah.
So even if the landlord called and the police said there's no, you're not gonna do anything, that call is still logged, that person called and
Yes,
so there would
it
still
should be, yeah.
be proof that they did something.
Yeah, if there's it's either in the radio log or there's gonna be a very small case report of saying, talk to this person, here's what I said, no further involvement.
Okay, and then my other question, I know that in the town that I live in, we've got a larger police force and perhaps more resources. We also have an online reporting system. Is that also relatively common? So like I can go online and fill out a form and it sends it.
I mean,
I don't expect you to know for every police, but like.
It's been a couple of years, but I mean, there were tip lines, you know, I think you could go online, but I can't remember.
Okay, fair.
The only thing we had was the anonymous tip line.
Got it. Okay, which would be less loggable. But thank you.
Right. And I would again point out that the problem that needs to be solved, or that seems to need to be solved, is the removal of these particular residents from the building. Right? That's what was ultimately causing the issue. The landlord wasn't taking action to have them removed, but charging the landlord still does not solve the problem of having the tenants who are engaged in the behavior removed from the property. And that's really what appears to be the ultimate goal here, or the ultimate resolution for the other tenants in that building. That's the relief that appears to be appropriate, right? Those tenants engaged in this illegal activity lose their housing, or removed from the building. Charging the landlord criminally is still not going to have that happen.
Any other questions or comments? Thank you very much. Appreciate the testimony.
Yes. Thank you for having me in, and happy to follow up or provide additional information or work on any of those other proposals if the committee so
We'll
wishes.
certainly look at changes to the bill as it currently exists regarding the landlord.
All right. Thank you very much.
On S4, we did provide a little time for committee discussion. And I think I'll let you know that we're awaiting work by Marshall Paul and Erica Mathich on the useful offender sections and how to improve that system. We're also have a meeting tomorrow along with Eric, people from the Justice Center, the Council of State Governments, and we may have them in next week to talk to us about some of the nationwide efforts to combat violence, some of their recommendations. And we also have go over, we should have, we have testimony from a number of witnesses regarding the firearm provisions in S4. That's tomorrow, is it, Peggy?
Yes, tomorrow morning at 9.
And we have Rebecca Turner and Daryl Miller and somebody from the, we're not going to get to everybody that's listed tomorrow.
Yeah, we have,
We're not gonna get
the mayor's
three.
gonna come tomorrow, and Allison and Amy are coming on Wednesday.
Who's coming tomorrow?
The mayor.
Mayor Weinberg.
Yeah.
And Daryl Miller and Rebecca Turner.
Yes.
All right. And then next week we'll hear from other folks on the violence, as well as we need to go over the administration's proposals. So there's going to be a lot of work left on S4. So I think it's too early to begin redrafting it, but certainly the section on landlords, I think, look at how to deal with that.
Yeah, whatever thought the committee may have.
I mean, I certainly support the sort of more explicit language around steps a landlord can take that he should use. That seems really reasonable and clearer as to what you're trying to get at to me.
Yeah, no, it could be phrased as an or. In other words, I think one of the concerns mentioned was, well, the concern about having to commence a breach of lease eviction that might involve or require other tenants who didn't want to be. No, you could say or. In other words, they report to law enforcement or they commence an eviction proceeding, so they could do one of them.
And I'm interested in talking about the knowingly or recklessly standard. I just want to make it narrowly focused and clear that this isn't for the landlord who is trying to do a good job. They just got unlucky and got a tenant who's an issue. I want to make it clear that it's for the landlords who know that drugs are being trafficked or that their property is being used as a nexus to traffic drugs, and they either don't care or are involved in it directly. This isn't for the landlord who's trying to do a good job or living in another state or something like that.
Well, I mean, maybe in some instances it might be for the landlord who's living in another state and has been complained to repeatedly and has not even bothered to call police.
Yeah. If they're deliberately disregarding that,
Yes.
that's a problem. There are just challenges and risks with creating third-party liability. Yes.
No, but I definitely am supportive of narrowing to really get at what you were trying to get at. The question I have is if we start listing call the police or begin eviction proceedings, are those the only two acceptable steps? Because I also think it might, installing cameras might be a step in the direction of gathering more information. So I do worry when we start listing explicit things that we then don't list everything.
We could say including but not limited to.
Yeah.
And that way we give examples of the things.
Mhm.
Where the landlord just tries to have a one-on-one with the tenant and says, you either need to knock this off or move out. But that's not documented anywhere. It's just a conversation.
Yeah.
It's still a step that they're taking.
Yeah. I mean, I suppose the landlord could document that.
Yeah.
Have the tenant sign it, I don't know. Good morning at work. I think there's ways to do that, but I always worry when we start making lists that we'll forget
Start
something.
as a draft of section 3. That's the land, or
Yeah.
was the landlord.
2 and 3, they're both, yeah.
2 and 3, the
Yeah.
landlord.
Eric, could I just ask, I'm looking at knowingly or recklessly. And the definition of recklessly means consciously disregarding, which feels like knowingly to me. So is there an additional piece that's brought in by the word recklessly, or is it sort of belts and suspenders for similar activity?
I think it is different, and it tracks specifically that language is taken verbatim out of the Vermont Supreme Court decision that's defining reckless criminal conduct, the mindset of recklessness for purposes of criminal conduct. I think the idea is that what you are conscious of is not in other words, the knowingly applies to that the structure is, and I'm looking at lines 9 and 10. The structure is used for the purpose of illegally dispensing or selling or making it drug. You know it. As opposed to the consciously means what you're consciously doing. You're not consciously necessarily aware that building is being used for that. But what you are consciously doing is that you've been made aware of a risk, and that's what you're intentionally /knowingly disregard.
Okay, so in other words, somebody might have complained, so there's the possibility you're going to disregard it, and you don't know that it's happening.
Right. Maybe you know that the police came by 3 times.
Yeah.
But you say, well, I don't know that. Not necessarily.
Yeah.
Knowingly is a higher standard
Yes.
for recklessness.
Yes.
The other area is the dangerous weapon. I think pretty much agreed the dangerous weapon is firearm.
Yes, that was was that this? Was that the shop purchasing or?
That's under section 3, page 5, line 10.
Oh, I see, right.
Well, anywhere we talk about dangerous weapon, but it's in the heading too. Knowingly or recklessly committing human trafficking or carrying dangerous weapon while committing a felony in a dwelling. And then there are other places where we use the term firearms, and then places where we use dangerous weapon. I think we generally agreed by the committee should be firearms.
One thing I'd like to point out is the fines. $100,000 seems ridiculously high. I know that landlords, there's the idea that they have deep pockets, but I haven't seen a fine that high. And regardless of how much money we think a person has, it just seems really, really high. And I think maybe we can consider bringing the fine down to make it more on par with the other fines that we have.
It's 1,000 more. Right?
Yes, and we have written 100,000.
Maybe 10.
Yeah, between 10 to
Well,
20.
What are we auctioning off now?
I think federally it was 15 grand.
And it's not more than, so, the vast majority would be under that, but I think it's a good point. It's to go from 1,000.
I think we could look at all the fines.
Lining up with federal seems reasonable. There's a lot of places in this bill where we do that. You said you think federal is 15,000?
Yeah, I believe so.
Well, if Eric could check the federal standard, because we've got 100,000 onto the section 2, 100,000 in section some other sections, the section 5 of 100,000 section.
Yeah, I just don't think any of these should be $100,000 fine.
But if we follow the federal law, though, I think the federal law is 20 years
20 years and 500,000.
and 500,000.
Okay, so maybe we shouldn't line up.
I don't know where I
with
heard Just kidding.
Go ahead.
Mine
On that
does,
note.
mine doesn't have as much to do with that, but in one of the concerns I have about carrying a dangerous weapon, or even if we change it to firearm while committing a felony, is in some of the felony property crimes that, you know, I might be walking around with my sidearm and throw a brick through a window, and I don't know that that window is $1,000 window. And so I definitely do have some concerns, you know, that maybe it's a violent felony, but I do have some concerns around spaces where we may create problems that I don't think this is trying to get at.
Okay.
So just wanted to,
I take the point, we talked in a similar way about dangerous weapon, it could be a knife that somebody has on it.
mhm.
I'm a little more sympathetic to that. If somebody has a gun on them and they're throwing a brick through a window, then I think I do want them picked up on this particular piece. Because they should know if they've got a gun on them. Different situations than just having a pocket knife or something.
I just feel like some of our misdemeanor to felony line crosses are rather arbitrary, and there would be no way of knowing that you are in fact committing a felony in the moment. And so, I mean, yeah, that's just where it gets kind of
Yeah.
murky for me.
No, it's true. The arbitrariness is all the way through the code. It's like,
Well, if I look at page 8, line 15, page 8 on line 15. That's where you committing a felony, person who carries a dangerous or deadly weapon, until they're concealed, the prison not more than 5 years. And that's current law.
Right.
But the conduct that we're adding is the conduct constituting the offense of carrying a dangerous or deadly weapon shall be considered a violent act for purpose of determining bail. And that, if we focused on the firearm and it was a violent felony, is that what you're?
Yeah, I mean, I just speak, again, because of, and particularly what I think about is property crime, it's just entirely arbitrary. And someone may look at this and be like, oh no, like, I forgot to, you know, I'm thinking some 16, 17-year-old is like coming out of the woods hunting, forgets to take their gun off, they're mad at their girlfriend, they throw a rock through the window, they don't know that that's $1,000 window, they're not being violent, they're being petty. So I just have concerns with it, particularly in the areas where the person who's engaging in the behavior would have no way of knowing, is this a misdemeanor property crime or a felony property crime?
Do you mind if I wait just a
No,
second?
not at all.
And when I came in and I testified cursorily at the beginning, I anticipated we were gonna come back and talk about this in more depth. But one of the things that is a disconnect here is bail is only supposed to be used to ensure appearance. So how the carrying of a weapon weighs at all on the issue of whether or not you're going to appear, there's a constitutional disconnect that carrying a weapon, whether it's dangerous, whether it's a fire, whether it, you know, whether it's a knife, whatever it is, how does that provide any evidence or indicia of what your bail should be relative to appearance?
The way I read this is that it is whether or not you should get bail. And maybe I'm wrong, but that's certainly how I read it, because when we've talked in this committee about violence and bail, it's been around whether or not you're even eligible for bail.
right, and maybe that's what, Matt, is that what you're pointing to?
Well, that's part of it.
Should it perhaps be reworded so that it says acts for the purposes of determining whether the person will be held without bail?
Yeah, I think that's what.
If you've got to qualify under that statute, you've got to, it can't be, you've got to be charged with a crime that you would be held without bail before, that you might be held without bail, or you're not automatically entitled to bail, before you can then be determined to have this factor be part of your situation. It can't be about bail. You have to already be in the category of potentially being held without bail.
But this language is used in various places in existing law and statutes, right? As a policy matter, and you're right, they're still gonna have to make the argument under the bail statute, and this doesn't guarantee that anyone gets out without bail. It just means that the factors that the court has to consider when deciding whether the offense is bailable, one of them is whether it's a violent offense, right?
Correct.
So this says, for that factor,
But that isn't what that says.
you don't read that, well, that's what it says elsewhere.
I mean, what I would do is reference specifically the hold without bail statute, as opposed to just let it sit there and not there.
Probably consider violent act.
Let it on its face, it looks like Constitution.
Right, proof determining bail under 13 BSA, whatever. Right, yeah, that makes sense.
Now,
Perfect, because the other concern I have with this is sort of on the other side. As far as I know, things like stalking are misdemeanors. And I frankly would find it much more violent if I was being stalked by a partner carrying a gun. And so for me, this sort of covers things I don't think it should, and doesn't cover things that actually are inherently threatening.
that's not,
This starts misdemeanor.
Well, I didn't catch the question, I'm sorry.
is stalking a misdemeanor or a felony?
Both.
Both, right, I think of it as a low-level misdemeanor.
Is stalking misdemeanor, is stalking felony.
Right.
Depending upon the number, that's one of them,
Mhm.
and what actually went on.
The language here, I feel like, I get where we're trying to go with it, and I think I agree in theory, but I don't think this language covers what it should.
I think, well, Eric, I
Perfect.
think this has been a good discussion, even though it was only 15 minutes. So it's a start. It's a start, and we'll pick up here next week on, well, we're coming back after a break at 11, but as for, it's complex stuff, but I think we're going to continue to deal with it. And we're gonna hear from a lot of experts next week and tomorrow. Rebecca Turner, Daryl Miller from Duke University, and Mayor Weinberger, and then the following week we'll hear from Judge Davenport, Allison Scheid from Town for Gun Safety, and somebody from the Federation of Sportsmen Clubs. Constitutionality under the law.